Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello, welcome to podcast number 146. This is the first of our usual episodes after the ones that we've been doing, the Best of 2018 episode and the Introduction to Employment Law in Saudi Arabia and Dubai. Do go back and listen to both of them. One in particular on employment law in Saudi Arabia and Dubai, and the things that can be surprising for employers coming into the region for the first time is well worth a listen. We've got three cases in this episode covering disability discrimination, worker status, and a short follow-up on the issue of privacy in the employment tribunal system and Law Society guidance on non-disclosure agreements, all loosely around the theme of privacy. As always, don't forget a variety of places that you can listen to this podcast. It's on YouTube, it's on iTunes, it's on the Mayor Brown web, and if you follow me on Twitter, Nicholas Robertson at Nicholas ROBER11, then there are links to the various cases posted too. So, without further ado, let's kick off. Williams and the trustee of Swansea University Pension and Insurance Scheme. So this is a case that has gone all the way up to the Supreme Court to do with disability discrimination. And reading it reminds me a lot of the comment by Lord Justice Mummery in the Clark and Novacold case, something like 20 years ago now. Quote, anyone who thinks that there is an easy way of achieving a sensible, workable and fair balance between the different interests of disabled persons, of employers and of able-bodied workers in harmony with the wider public interests in an economically efficient workforce has probably not given much serious thought to the problem. So here you have what looks like a deceptively simple question. The answer seems obvious until you actually think about it. Let's see what you think. Mr. Williams worked for the trustees, worked for the Swansea University, I should say, had mental health issues, including depression, and these were known to the employer. And so there was no dispute that he was disabled for the purposes of the Equality Act 2010. He worked on a full-time basis for a number of years, and then latterly worked on a part-time basis because of adjustments connected with his ill health. That didn't work, unfortunately, and so in May 2013 he applied for ill health early retirement under the pension scheme, and this application was successful. And he was 39 at the point at which he retired. Now, the effect of getting the ill health early retirement pension was that he became entitled to receive a lump sum and an annuity based on his accrued benefits and a pension without any actuarial reduction for early receipt. And bear in mind he was retiring at 39, so that's obviously by itself quite a benefit. The annuity and the lump sum were both calculated on his actual salary. This non-actuarially reduced pension was then further enhanced by him being deemed to have remained in service up to the normal pension date, which was based on the retirement date under the scheme, which was, in this case, age 67. So he was receiving, in effect, an enhancement based on the notional 28 years or so of future work, which would have remained open to him. Well, Mr. Williams brought a claim under Section 15 of the Equality Act 2010. Now, we've seen quite a number of cases in recent podcasts on Section 15, but just by way of reminder, Section 15 of the Equality Act says that, quote, a person, A, discriminates against a disabled person, B, if A treats B unfavourably because of something arising in consequence of B's disability, and A cannot show that the treatment is a proportionate means of achieving a legitimate aim, unquote. So how did Mr. Williams manage to claim that Section 15 had been breached by the university? His argument was that he had received less by way of a pension than he would have received had he been fully fit. In other words, had he been fully fit, he would have remained on full pay, then his pension would have been calculated on his service up to that point, but on full pay. Therefore, he said, the university has to justify why it was calculating his pension on a part-time basis. That was, he said, treating him unfavourably because of something arising in consequence of his disability. The Employment Tribunal agreed with him, said he had been treated unfavourably by reason of something connected with his disability. They further said the university had failed to justify that detrimental treatment. The university appealed, unsurprisingly. Mr. Williams lost in front of the AT, lost in front of the Court of Appeal, and the matter went all the way up to the Supreme Court, in essence to look at what does it mean to treat someone unfavourably. This is where one of those questions where you think, for heaven's sake, the answer's obvious. And then you start thinking. Well, in essence, the Supreme Court said there were two questions that had to be answered. First, what was the treatment Mr. Williams was complaining about? Secondly, was that treatment unfavourable? Well, the Supreme Court, in a unanimous decision, dismissed the appeal from Mr. Williams. They looked at the purpose of Section 15 of the Equality Act. This was introduced to remove the need for a disabled claimant to show that a comparator would have been treated better than the complainant, and therefore the claimant had been treated adversely. So that's why the issue in this case, and the issue in Section 15, is whether the individual, in this case Mr. Williams, the claimant, has been treated unfavourably. It didn't matter how anyone else had been treated in comparable circumstances. The Supreme Court said, although there is not a statutory definition of treating someone unfavourably, the ordinary discrimination concept of subjecting someone to a detriment in the Equality Act is a very similar concept. So there, in that context, the case of Shamoon indicates that an individual can suffer a detriment, even if it's not a financial detriment. It's enough if a reasonable individual might take the view that they had suffered disadvantage. On the other hand, although the threshold is low, the Shamoon case says an unjustified sense of grievance would not suffice as a detriment. So here, the Supreme Court, in a relatively brief judgment, was of the view that the pension granted had nothing intrinsically unfavourable or disadvantageous about it. Since the only basis of Mr. Williams getting any pension at all from age 39 was because he was disabled, he'd clearly been treated more favourably than a non-disabled employee. If he'd been able to work full-time up to the point at which he retired, 39, he would not have had a right to a pension at all from age 39. It was not in any sense unfavourable treatment, and it could not reasonably have been regarded as unfavourable not to have given him a more favourable pension than he would have had he not been disabled. In other words, because he was getting a clear benefit from having been disabled and retiring, then he was not being treated unfavourably. The Shamoon test was the treatment such of, quote, such a kind that a reasonable worker would or might take the view that in all the circumstances it was to his detriment, unquote. That test was not met here. A reasonable worker would not take the view that Mr. Williams was being treated to his detriment. Now, clearly the first reaction on listening to this may be to wonder how this case ever got to the Supreme Court. He got an enhanced pension. However, undoubtedly the claimant had suffered because of his disability. That had led him to a worse pension than he would otherwise have received. Or put it another way, there was a link between his disability and the pension that he received, and that did not in all circumstances work out in his favour. But I think the Supreme Court was surely right. Given that he was being treated more advantageously than any non-disabled employee could have been, it was difficult to say he was being treated disadvantageously just because he could have been treated even more favourably than he was already being treated. So the question then is where this case takes you. The Supreme Court has identified the test for whether someone has been treated unfavourably for Section 15 purposes, which looks at the view that a reasonable worker might take of a situation as to whether or not something was to his or her detriment. Fine. And there may be cases arising where the alleged detriment is so marginal that it could be fairly said there's been no detriment and therefore there is no Section 15 case to answer. I did wonder whether this case might have an application, for example, in circumstances where, say, an employee is dismissed because they're unable to attend work due to a disability. The disability, I should say, is known to the employer. They've been allowed, let's again just say for the sake of argument, double the number of days off before the employer dismisses them than they would have had they not been known to be disabled. Could the employer say here, the treatment is not disadvantageous to a disabled person, it's advantageous. They had 40 days, not 20 days of absence, and so Section 15 cannot apply. But I think the treatment in this hypothetical example is the dismissal, the adverse treatment. The complaint, therefore, is not dismissal after 40 days of absence rather than 20. So I don't think the Williams case says that just because a disabled employee has been treated more favourably in some ways, it necessarily means that Section 15 of the Equality Act would be defeated, in which case presumably the matter would have been left to be run as a reasonable adjustment claim. But let's see. It'll be interesting to see if anyone tries to run an argument, and I'm still holding out for my podcast to be cited in a reported case. Prizes for anyone who achieves that. Anyway, that's Williams and the trustees of Swansea University, which decides on the test for establishing whether, under Section 15, someone has been treated unfavourably. Next up, Uber and others, and Aslam and others. And this is the long-running Uber versus its drivers case, which has been working its way through the system, and which we discussed at the Employment Tribunal and EAT stages. I'm quite sure that if you asked the reasonable lawyer on the Clapham omnibus, or whatever the test is these days, what was going to be the outcome of the Uber case, they would take it as read that Uber is playing a losing hand to the end of the game, and the upshot is the courts are definitely going to find that the individuals are clearly workers. I think the Court of Appeal would give the lie to that assumption. I think it's going to be a rather closer run thing than the widely assumed stroll to victory for the drivers. I've got a vision that the lawyers acting for Uber could yet end up in the position of the lawyers acting for Unison during the Tribunal Fees challenge case. And if you remember, Unison and its lawyers lost at every stage and pursued a battle for what they saw as justice, won handsomely in the Supreme Court, and were rightly recognised for their persistence and contribution to protecting the rights and development of employment law. It would be entertaining to think that Uber's lawyers might yet receive the same recognition. Maybe not. Anyway, the case concerns tribunal action brought by various drivers who are claiming that they are workers retained by Uber rather than self-employed individuals. And their case is that they are so-called Lim B workers. And that's a reference to Section 230(3)(b) of the Employment Rights Act, where an individual is a worker if they work under a contract whereby the individual undertakes to do or perform personally any work or services for another party to the contract, unless that other person's status is that they're a client or customer of a profession or business undertaking carried on by the individual. In other words, if you have a contract and you're obliged to provide personal service and you're providing services for another party, then you're a worker unless that other party is a client or customer of your profession or business. Unlike the Deliveroo case, which we've also covered on the podcast, where their individuals were not under an obligation to provide personal service because they could send along substitutes, but here the regulatory regime means that no such avenue is open to Uber. As we all know, the Employment Tribunal and the EAT both decided their case against Uber. They decided that the individuals were workers. They also decided that for the purposes of the working time regulations, individuals were working during any period when they were within their allotted territory from Uber, had the Uber app switched on, and as such were ready and willing to accept work. Consequence of all this is that the drivers would have the right to seek national minimum wage and the right to paid annual leave. At the Employment Tribunal stage, there were 4 issues applicable. 2 of these, the finding that English law applied to the dispute and that the claimants were engaged in, quote, unmeasured work, unquote, for the purpose of the national minimum wage regulations, well, those 2 issues were no longer current. Therefore, the 2 issues that remained were whether the claimants were employed by Uber as workers, within the Lim B test, and the working time. How is that to be assessed for each of the claimants? Well, in essence, the majority of the Court of Appeal decided that the Employment Tribunal was entitled to come to the decision it did. Like the Employment Tribunal and the EAT, the Court of Appeal majority relied heavily on the AutoCleanse case, where the Supreme Court said that in certain circumstances, courts or employment tribunals could disregard terms which were included in a written agreement between the parties, and instead take the view that the documents did not reflect what was actually agreed between the parties as to their true intentions and expectations. There are also references in that AutoCleanse case to the court or tribunal being, quote, realistic and worldly wise, unquote, when it investigates an assertion that the written contract does not reflect the actual terms agreed. So, the majority decided that Uber's appeal should be rejected on the grounds the Employment Tribunal was entitled to come to the decision it did on both points. And indeed, the majority go as far to say that they think the tribunal made the correct decision. But my reason for labouring this point slightly is that the minority judgment from Lord Justice Underhill makes a pretty compelling case that Uber might be right after all. First, he points out there are ample examples of minicab businesses being structured in a way which is very similar to the way which Uber seeks to present itself, and which have been accepted as valid by the courts. On that basis, he says, there is nothing inherently artificial or unreasonable about what it is saying. Secondly, he goes through some of the more flowery language used by the Employment Tribunal to try and justify its findings, and he does a pretty good job of demolishing a lot of them, saying that they are at least as consistent with Uber's version of events as the claimant's. It follows from this, he says, that AutoCleanse gives no warrant for disregarding the terms of the agreement. He accepts that AutoCleanse is an important tool in the tribunal's armoury to look at the reality of the relationship rather than the false characterisation imposed by an employer. Quote, but the premise is that the characterisation is indeed false, unquote. AutoCleanse does not, he says, permit the rewriting of agreements because they are disadvantageous. And similarly, he takes issue with the idea that drivers are working merely by virtue of being in their allotted zone with the app turned on. He points out they can, of course, be waiting for work from other carriers as well. Therefore, how can it be work for one party, not the other? Seems a pretty fair point to me. Well, the upshot of this is the Court of Appeal has itself granted leave to Uber to go to the Supreme Court, so clearly we've not heard the last of this case yet. I think it'd be very interesting to see whether Lord Justice Underhill's potential demolition of the Employment Tribunal's reasoning gains any support in the Supreme Court. Equally, the extent to which AutoCleanse cannot be used to rewrite bargains simply because they're disadvantageous does seem to me, at least, to be a pretty powerful point. That said, if I were a betting man, I think the Supreme Court will probably say the tribunal was entitled to come to the view it did, but let's see. So that's Uber and the ongoing story of the worker status for its drivers. Third and final case is Amayor and PricewaterhouseCoopers Services Limited. Now, this is an EAT decision where a claimant was seeking to have records relating to her removed from the Employment Tribunal Public Register. Now, the background is that, as I'm sure we all know, the Public Register of Tribunal Judgments and Written Reasons, well, it's been public for a couple of years now. All judgments, any written reasons for a judgment are on the register, as are names of parties and the type of the claim. For those of you who regularly listen to the podcast, I did a podcast with David Reed on privacy in the Employment Tribunal system, and that went out shortly before Christmas. And it's genuinely well worth a listen. Well, under Rule 50 of the Employment Tribunal rules, there is the opportunity for a tribunal to restrict or to prevent the public disclosure of any aspect of the proceedings if the tribunal considers that it's necessary in the interest of justice or to protect an individual's rights under the European Convention on Human Rights, for example. Well, the claimant brought tribunal proceedings against PricewaterhouseCoopers. It was a preliminary hearing which seems to have got somewhat out of control. It seems the Employment Tribunal judge at that point was of the view that the claimant and her mother both behaved in a way that was disruptive of the proceedings. At the next hearing, the respondents made an application to strike out the claimant based on that behaviour. The strikeout application was unsuccessful, although the tribunal decision records the claimant undoubtedly lost her cool at times during the hearing and behaved reprehensibly. She didn't do so without justification, unquote. Well, the case then rolls forward, goes to a full hearing, which results in all the claimant's claims being dismissed. But a year after that, when the claimant has been unable to find alternative employment, apparently, she applies for an order saying that the final judgment hearing should not be entered on the register, and the same approach should be taken with the strikeout judgment. She says that the effect of what has happened and the adverse comments made about her have stopped her getting employment elsewhere. As a fallback, she says that her name should be anonymised. The Employment Tribunal refused her application, and she appealed to the Employment Appeal Tribunal. I would add that if you look up the case online, the full decision at the end of the day is not available. The full Employment Tribunal decision hearing coming to the dismissal of all her claims is not available online for some reasons. I don't quite know what's going on there, but the strikeout decision is. The EAT's view was, of course, that open justice should only be curtailed if there are other competing rights, which effectively mean that justice would be denied if the principle of full open justice is not applied. Well, the EAT was clear that unless the case was one involving national security, I nearly said national insecurity, there's a Brexit joke if ever I heard one. If it was a case that involved national security, unless it did that, and involved national security, it had no authority to preclude the case being put onto the register at all. Rule 50 of the Employment Tribunal rules does give an Employment Tribunal a broad discretion to restrict judgments for written reasons where they would identify individuals. Well, the EAT acknowledged that it could provide an order anonymising a party if the case concerned confidential information, disability or other similar European Court of Human Rights matters, or sexual misconduct. But they thought it was rare, quote unquote, that there would be other circumstances in which an indefinite restriction would be imposed on the register rather than, as we've seen in the past, interim restricted reporting orders pending the outcome of a particular case. Accordingly, the issue was, since the tribunal could not exclude judgments from the register, whether the claimant should have been granted anonymity. The EAT said that Article 8 of the European Convention on Human Rights was not engaged, given that the hearings would be taking place in public, so there could have been no expectation of privacy on the claimant's part in relation to what happened at those hearings. The EAT accepted the Employment Tribunal had been entitled to take the view that Rule 50 disclosed no basis here for overruling the principle of open justice in the present case. Now, clearly these facts are unusual, although the tribunal judge hearing the strikeout indicated that they were hardly unique in their experience. Well, my reasons for mentioning the case is just to say that even if a party behaves disgracefully, the tribunal's focus is usually on whether their behaviour has meant it is so bad that it endangers the possibility of a fair hearing at a future date. Equally, though it is important to recognise that tribunal decisions and written reasons will be on the register, we are certainly aware of examples where this has caused concern, particularly to people named in judgments but who are not parties to it, not parties to litigation. The parties involved in tribunal litigation obviously need to be mindful of the fact that not only the hearing itself, but any public interim hearings and their outcome will be public and end up on the register unless exceptional circumstances apply. In a related point, I would commend, as they say, to anyone who's not yet read it, the Law Society's note on non-disclosure agreements and confidentiality clauses in an employment law context. It came out on the 7th of January 2019, and it is, I think, for employment law, essential reading. In essence, it says that there are issues around professional conduct for lawyers who are putting forward and presumably advising their clients to sign excessively wide non-disclosure agreements. In the circumstances, I think it's necessary to go back and look at any precedent contracts, employment or settlement agreements that you have. I also think if you're acting for an employer and you have an unrepresented litigant on the other side, and so you're advising on settlement through a COT3 agreement at ACAS, it's very important the process is seen to be fair and reasonable, since otherwise the NDA itself might be open to challenge. And you also need to think about the exclusions flagged in the Law Society's note, and whether you're going to incorporate those exclusions, those permitted circumstances for disclosure, into your precedent documents. So that's Ameyor and PricewaterhouseCoopers Services Limited and the Tribunal's ability to, at discretion I should say, to anonymise tribunal records going on to the public register. So, thank you very much indeed for listening. Podcast number 150 is coming into view in the next month or so. So, I'd just like to say thank you very much to everyone for listening during 2018, and we're underway for 2019. Thanks indeed.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.